Lorna Johnston, the Executive Director of the Standards Commission, and today I'm going to be talking about the Councillors' Code of Conduct. I intend to provide a brief outline of the ethical standards framework to provide context before moving on to discuss the main provisions in the code. I'll also talk about the Standards Commission's guidance and educational material, which is aimed at helping you as a councillor interpret and comply with the provisions in the code. The Standards Commission's overall aim is to ensure councillors and members of devolved public bodies meet the high standards of behaviour that the public is entitled to expect. The Standards Commission aims to take a proactive approach by raising awareness and understanding of the provisions in the code. We do that by issuing guidance, advice notes and standards updates, and through training events, and by answering queries and providing advice to councillors, council employees and members of the public. The Standards Commission's overall aim is to prevent breaches of the code from occurring, but it also has an enforcement role through its work on adjudicating on complaints and in imposing sanctions when a breach of the code is found. Investigations into complaints alleging that a councillor has breached the code are undertaken by the Ethical Standards Commissioner, who is a separate and independent office holder. On completion of the investigation, the Ethical Standards Commissioner's office will refer a report to the Standards Commission outlining its findings. The Standards Commission has three options when considering the referral report. It can do nothing, which means that no further action is to be taken on the complaint. It can direct the Ethical Standards Commissioner to undertake further investigation, or it can hold a hearing. The Standards Commission holds hearings, usually in public, to determine whether a breach of the code has occurred and, if so, to determine the appropriate sanction to impose. Hearing panels comprise of 3 members of the Standards Commission. Hearing panels are obliged to impose a sanction if they find that a breach of the code has occurred. The Standards Commission has published a policy on the application of sanctions, which outlines the factors that hearing panels will consider when determining what sanction to impose. This includes the seriousness of the breach and impact on others, and any other relevant aggravating or mitigating factors. The appropriate sanction will depend on the facts and circumstances of each case. The sanctions available to the Standards Commission are censure, suspension and disqualification. Censure is the formal recording of the Standards Commission's severe and public disapproval of the councillor's conduct. A full suspension means that the councillor is not entitled to attend any meetings of the council. This includes any committees and subcommittees, and also any meetings of any other body of which the councillor is a representative or nominee of the council. Partial suspension means that councillor is not entitled to attend certain specified meetings or committees of the council. The Standards Commission can also disqualify a councillor from being or standing for election as a councillor, and that's for up to 5 years. So turning to the code itself, the provisions in the code are written in the first person. For example, I will or I will not do something. And the aim of that is to encourage ownership and engagement. The introduction section outlines when the code will apply, and I'll talk about that more in the next slide. The introduction section emphasises that it is your personal responsibility as a councillor to be familiar with and to comply with the provisions of the code, the law, and your council's rules, standing orders and regulations. It provides that you will not, at any time, promote or encourage any action that is contrary to the code. Section 1 provides more information about when the code will apply. The code does not apply to your private or family life. It only applies when you're acting as a councillor and or when you could reasonably be perceived as acting as a councillor. In determining whether the code applies, the Standards Commission will apply an objective test and will consider whether a member of the public with knowledge of the relevant facts would reasonably consider that you are acting as a councillor at the time of the events in question. The code states that this can include when you're engaging in online activity, such as posting on social media. The Standards Commission's guidance notes that, due to the public nature of social and print media and your profile as a local authority member, you may wish to consider whether members of the public might automatically assume that you're commenting on your role as an elected politician in anything that you post, publish, or share online or in the media. This doesn't mean that you're prevented from expressing views and making political comment. You are just required to do so in a way that is compatible with the code, and that's the substantive provisions in the code, which are the ones contained in sections 3 to 7 and Annex A. This includes the requirement to behave with courtesy and respect and to maintain confidentiality. You're encouraged to seek advice if you're unsure about whether the code applies. Section 2 of the code outlines the key principles of public life, being duty, selflessness, integrity, objectivity, accountability and stewardship, openness, honesty, leadership, and finally respect. It should be noted that a breach of one or more of the key principles does not, in itself, constitute evidence of a breach of the code. However, the code notes that the key principles can be used by the Ethical Standards Commissioner's Office in its investigatory role and the Standards Commission in its adjudicatory role to assist with interpretation of alleged breaches of the substantive sections of the code. Section 3 of the code covers your conduct in general. The code requires you to treat your colleagues, council employees, and members of the public with courtesy and respect. This includes in person, in writing, at meetings, and when you are online. It also requires you to respect and comply with rulings from the chair or convener during meetings of the council, committee meetings, or meetings of any outside body to which you are appointed by the council. Paragraph 3.2 of the code provides that you must not discriminate unlawfully and that you will advance equality of opportunity. The code notes that bullying and harassment is completely unacceptable and will be considered to be a breach of the code. It notes that bullying and harassment can be a one-off incident, part of a cumulative course of conduct, a pattern of behaviour, and physical, verbal, and non-verbal conduct. The code further notes that it is the impact of the behaviour and not the intent that is the key. The code states that you should not become inappropriately involved in the operational management of the council's services, as that is the responsibility of its employees. It also states that you must not undermine any individual employee or group of employees or raise concerns about their performance, conduct, or capability in public. The code also provides that you must not take or seek to take unfair advantage of your position as a councillor in your dealings with employees, and that you will not bring any undue influence to bear on employees to take any actions. The provision prohibits you from asking or directing an employee to do something that you know or should reasonably know could compromise the employee or prevent them from undertaking their duties properly and appropriately. The code contains provisions on gifts and hospitality. These are designed to avoid any perception that councillors are using their role to obtain access to benefits that members of the public would otherwise be expected to pay for. They are also designed to prevent councillors from being influenced, inadvertently or otherwise, into making decisions for reasons other than the public interest. For example, by being influenced by serious organised crime gangs who are seeking to obtain contracts and licences to facilitate money laundering. The code makes it clear that the default position is that you should refuse all offers of gifts and hospitality, except in very limited circumstances that are listed at paragraph 3.15. It should be noted that acceptance can include accepting the promise of a gift or hospitality. The exceptions under paragraph 3.15 are A. Minor items or tokens of modest intrinsic value offered on an infrequent basis, such as a pen or a notepad. B. A civic gift being offered to the council. C. Hospitality that would reasonably be associated with your duties as a councillor or as a member of an arm's length external organisation. such as tea or coffee at a local event, or a buffet lunch included at a training event or conference. Or D, hospitality that has been approved in advance by the Council or the arm's length external organisation. In considering whether an offer of a gift or hospitality may fall within one of these exceptions, you are required to consider an objective test. This is whether a member of the public, with knowledge of the relevant facts, would reasonably consider that acceptance of the gift or hospitality might lead you to being influenced in your discussion or decision making. You should always question whether you would have been given the gift or hospitality if you were not a councillor. In doing so, you should think not just of your own perception, but also the perception of others. The Code nevertheless recognises that if you are representing your council in a civic role, you will be expected and allowed to accept hospitality associated with that role. An example might be a dinner to commemorate an anniversary of an event. Similarly, the Code recognises that there may be situations where you might be expected to accept gifts on the council's behalf, particularly if it could cause embarrassment or offence not to do so. An example could be a gift from representatives of a twin town or another organisation visiting the area. In such circumstances, you'd be required to accept the gift on behalf of the council and to pass it to the appropriate officer. You are also required to advise your council's monitoring officer promptly if you are offered but refused any gift or hospitality of any significant value, and or if you're offered any gift or hospitality from the same source on a repeated basis. This is so the council can monitor the situation and take action if appropriate. Confidentiality. The Code provides that you are not allowed to disclose confidential information or information which reasonably should be regarded as being of a confidential or of a private nature without the express consent of a person or body authorised to give such consent. If you can't obtain such express consent, you should assume it is not given. The Code makes it clear that confidential information is not just information deemed to be confidential by statute. It notes that such information can also include discussions, documents, and information which is not yet public or which is never intended to be public. Paragraph 3.23 states that you are only to use confidential information to undertake your duties as a councillor. It must not be used in any way for personal or party political advantage or to discredit the council, and that's even if you're of the view that the information should be publicly available. Sometimes confidentiality is a matter of timing, and the information may be released into the public domain at a later stage. However, you must respect the requirement for confidentiality, even if you consider that the information should be released at an earlier stage. You should seek advice if you are in any doubt as to whether any documents, information, or advice are confidential, particularly if you're intending to disclose their contents to an outside body or individual. The Code states that you can only use council resources, including employee assistance, facilities, stationery, and IT equipment to carry out council duties and in accordance with your council's relevant policies. While your council's policy may allow some incidental personal use, you are not allowed to use or allow others to use council resources, A, imprudently, and that's without thinking about the implications or consequences, B, unlawfully, C, for any party political or campaigning activities or matters relating to these, or D, improperly. The Code states that you must not use or attempt to use your position or influence as a councillor to improperly gain an advantage, avoid a disadvantage, or seek preferential treatment or access for yourself or others, such as friends and family. You are also required to avoid any action that could lead members of the public to believe that preferential treatment or access is being sought. Section 4, Registration of Interests. This section of the Code is intended to give members of the public confidence that decisions are being taken in the best interests of the public and not those of you or your family, friends, or personal associates. The register is intended to be a public record of the interests that might, by their very nature, be likely to conflict with your role as a councillor. The fact that you subsequently declare a registrable interest at a meeting would not necessarily be a defence to a complaint that you have breached Section 4 of the Code by failing to register it. You should, therefore, be as transparent and careful as possible when considering which interests you need to register. The register should cover the period from 12 months before your election and your whole term of office. For example, if you are newly elected or re-elected to office in May 2022, your register should cover your interests from the period commencing May 2021 and should then include the full subsequent term of office. Should an interest no longer apply, for example, if you cease to receive paid work from another employment during your term of office, the entry should still be listed in the register and retained for the whole term of office. However, you should amend the register to reflect the change of circumstances, for example, to put the start and end date of the employment. Ethical standards regulations provide that every council should have a register of interest for its councillors. You are required by the regulations to update your entries in the register of interest within 1 month of your circumstances changing. While your council may issue reminders, it is your personal responsibility to ensure your entry is updated within 1 month of a new interest arising or of your circumstances changing. You should also ensure that you review all your entries in the register at least once a year, even if you think nothing has changed. So what needs to be registered? Category 1, remuneration. You are required to register any work for which you receive or expect to receive payment or reward, regardless of how casual or trivial the work is in nature. Category 2, other roles. This is the requirement to register any unremunerated directorships where the body in question is a subsidiary or parent company of an undertaking in which you hold a remunerated directorship. Category 3, contracts. You must register an interest under this category where you as an individual or an undertaking that you have a substantial interest in, either as a partner, director or shareholder, has an upcoming or ongoing contract with the council for the supply of goods or services or for the execution of works. You do not need to state the value of the contract. Category 4, election expenses. The code states that you must register any single donation of more than £50 or any donations from the same source that together amount to more than £50 towards election expenses. This applies to any received by you or on your behalf within the period commencing from 12 months prior to and including your current term of office. Category 5. You are required to register any houses, land or buildings that you own or have any other right or interest in, such as being an owner or a tenant, including a council tenant. For personal safety reasons, you are not required to disclose your home address in the publicly available register of interest. You only need to provide details of the council ward in which the property is located. You are required to provide the full address of the property to the council's monitoring officer or their nominee, but this is to be kept confidential. Category 6, interest in shares and securities. The provisions under this category state that you have registrable interest where A. You own or have an interest in more than 1% of the issued share capital of a company or body, or B. Where, at the relevant date, the market value of any shares and securities in any one specific company or body that you own or have an interest in is greater than £25,000. The relevant date is defined in Annex B of the Code as the date on which you are elected and every 5th of April following that date. Category 7, gifts and hospitality. This category exists due to a previous version of the Code. However, as the 2021 version of the Code provides that you are no longer allowed to accept any gifts and hospitality, other than under the very limited circumstances previously outlined, there is no longer the need to register any. Category 8, non-financial interests. You're required to register any non-financial interests that fall within the objective test. These are non-financial interests that members of the public, with knowledge of the relevant facts, might reasonably think could influence your actions, speeches, votes, or decision-making as a councillor. Interests that might fall within this category could include membership of another public body, a club, a society, a trade union, or a voluntary organisation. Category 9, close family members. You are required to register the interests of any close family member who has transactions with the council or is likely to have transactions or do business with it. Section 5, Declarations of Interest. This section outlines a three-stage process to identify declarable interests and for you to understand what you are required to do if you have any. The first stage is identifying whether you have a connection. A connection is any link between the matter to be considered by the council and you or any person or body you are associated with. This could be a family relationship or a social or professional contact. A connection will also include anything that you have registered as an interest under Section 4. Paragraph 5.4 of the Code outlines matters that are not considered to be a connection for the purpose of the Code. This includes simply having previous knowledge or experience of a matter. It also includes being a council tax or ratepayer or a council house tenant, being a councillor when matters relating to elected members' remuneration, allowances, expenses, support services or pensions are being considered, or being a member of an outside body to which you have been appointed or nominated by the council, such as the Regional Transport Partnership, a Health and Social Care Integration Joint Board, a city-region deal, an arm's-length external organisation, or a voluntary organisation. This means that you can take part in discussions and voting on matters that could affect that outside body without having to declare your membership. That is unless the matter being considered is quasi-judicial or regulatory in nature and the outside body has an interest, i.e. as an applicant or an objector, or you have an additional personal interest. An example of where you may have a personal conflict other than just through your membership of the outside body in this context would be where your partner works for the outside body and where the body is seeking a package of funding from the council for its operations that could have an impact on your partner's job. It should be noted that a subject that may apply to a large proportion of the public would not generally be considered to give rise to a connection for the purposes of the Code, for example, being a taxpayer or being in receipt of a state pension or universal credit. If you have a connection to a matter being discussed, you are then obliged, under Stage 2, to identify whether it amounts to an interest that requires to be declared. In making this decision, the Code requires you to apply the objective test. This is whether a member of the public, with knowledge of the relevant facts, would reasonably regard your connection to the matter as being sufficiently significant as to be likely to influence your discussion or decision-making. It's important to note that the test is not what you yourself know about your own motivations and whether the connection would unduly influence you. It is about what others would reasonably think if they were in possession of the relevant facts. If the test is met, then the connection is an interest that requires to be declared. The Code makes it clear that the requirement to disclose or declare interests applies both in formal and informal dealings with council employees and other councillors, and not just in formal council or committee meetings. If you have a declarable interest, then, under Stage 3, you cannot participate in any discussion or voting on the matter. You should declare any interest as early as possible, and you must leave the room. It is not sufficient for you to withdraw to the back of the room or to any public gallery. If the meeting is being held online, you should go to a separate breakout room or leave and rejoin the meeting after the discussion on the matter is concluded. It is not sufficient for you to turn off your camera and/or microphone for the duration of the discussion. And this is to ensure that you do not influence other members and/or to avoid any perception that you could be doing so. You should be mindful of the need to protect the confidentiality of another person's business or financial interests when making a declaration. You're only required to provide enough information for those present to understand why you have a declarable interest. The Code notes that in some circumstances, you may consider it as appropriate, for transparency reasons, to state publicly that while you have a connection to a matter, you do not consider it amounts to an interest, and to explain why. Section 6 of the Code distinguishes lobbying from helping constituents and community engagement. Constituent inquiries. Dealing with constituent inquiries is a key part of your role and helps ensure the Council is open, accessible and responsive to the needs of the public. When you respond to a constituent, you should be mindful of the need to treat everyone with respect and to otherwise promote the key principles outlined in Section 2 of the Code. You are not obliged to respond to every inquiry, particularly if you cannot help the constituent further, but you should always consider whether it would be helpful to politely inform the constituent as to why you cannot help. You're entitled to raise a constituent's inquiry with the relevant Council employee, although you should, at all times, follow the Council's policies on the processing of personal data. You can ask questions about how a service has been delivered and can seek information on progress on behalf of a constituent, but you should be careful not to stray into operational management. Community engagement is another key part of your role, as it helps to identify communities' needs, determine Council priorities, contribute to more informed decision-making, and help the community empowerment and capacity building. The Code requires you to undertake any community engagement work in an open and transparent manner. You should note, however, that there is a distinction between community engagement and a single issue campaign about a regulatory decision. The Code notes that you should not express an opinion on a quasi-judicial or regulatory application that you might later be asked to determine. If you do express such an opinion, you will be required to declare an interest and will not be able to take part in the decision-making on the matter. Lobbying. The Code explains that lobbying is where you're approached by an individual or organisation who is seeking to influence you for financial gain or advantage. The Code again requires you to have regard to an objective test in deciding whether, and if so how, to respond to such lobbying. You must consider whether a member of the public, with knowledge of the relevant facts, would reasonably regard your conduct in responding to the lobbying as being likely to influence your or the Council's decisions. If you are approached by a lobbyist, it is likely that they are seeking your involvement as someone in a position of influence, whether as part of the decision-making committee or otherwise. It is important to recognise that there is a difference between lobbying on behalf of a commercial or personal interest and lobbying for a policy change or benefit which affects a group of people, a community, or an organisational sector. You should always consider what will benefit the Council area as a whole and not just any narrow interest. You must not, in any case, accept paid work in which you give advice on how to influence the Council or its decision-making processes. The Code lists what you should and should not do if you're approached directly by an individual or organisation who is seeking to do business with the Council or who is involved in a quasi-judicial or regulatory matter, such as being an applicant or an objector. This includes that you will advise the individual or organisation that you cannot formulate an opinion or support their position if you're going to take part in the decision-making on the matter, and that you will direct representations you receive to the appropriate Council employee or department. The Code notes that you will not lobby or otherwise exert pressure or influence employees and your colleagues to either make or recommend a particular decision. It further states that you will not use political group meetings to decide how you and other councillors should vote on such matters. Section 7 of the Code covers quasi-judicial and regulatory decision-making, such as decisions being made in respect of planning and licensing matters and statutory appeals. These decisions will often have a significant impact on the applicant and others. The Code notes that there may be formal legal routes beyond the Council to challenge a decision made on a quasi-judicial or regulatory matter. As many of the decisions will be controversial, they may be subject to intense scrutiny. A failure to observe the terms of the Code or a failure to avoid any reasonable perception that you have done so could result in a challenge against the Council's decision with associated cost implications. A successful challenge can have an adverse effect on the Council's reputation as well as your own. Even if such a challenge is ultimately unsuccessful, it's still likely that the Council will incur costs. The Code requires you to make quasi-judicial or regulatory decisions objectively and with an open mind. It lists what you should and should not do when considering and making such decisions. For example, the Code states that you will act fairly and be seen to be acting fairly, and will take into account professional advice given to you by Council employees, and that you will tell those who may be seeking to influence you out with the proper decision-making process that you will not formulate an opinion on any particular application until all information is available to all decision makers. The Code notes that you will not prejudge or demonstrate bias or express any view on an application before the appropriate meeting, that you will not attempt to influence employees to adopt a particular position or lobby other councillors, and that you will not make a decision until all available information is to hand and has been duly considered at the meeting. The Code singles out decisions on policy and strategic issues under which individual applications may subsequently be decided, and again outlines what you can and cannot do in respect of these. For example, it notes that you can support proposals that you consider to be of benefit to the Council area, but states that you cannot express any view that suggests that you have a closed mind on the policy or strategic issue, regardless of any material considerations. The Code also outlines how you can make representations on a specific regulatory or quasi-judicial matter, both when you are and are not a member of the decision-making committee. For example, it states that if you are a member of the committee, you must declare an interest in the matter and can only remain in the meeting while the matter in question is being discussed for the purpose of making the representations. In circumstances where you wish to make representations on a matter but are not a member of the committee, you can only do so in accordance with your Council's procedures for any member of the public or parties wishing to make such representations. Site visits. The Code notes that you are required to follow your Council's procedures for site visits. As site visits can form part of the committee process, a degree of formality should apply and you should behave accordingly. You must follow your Council's procedures in making site visits as part of the committee process and must not give any impression during a visit that you have made up your mind prior to any decision-making meeting. Annex A of the Code outlines the different roles councillors and council employees have and how they should behave towards each other. The key message detailed at paragraph 2 of Annex A is that councillors and employees should work in an atmosphere of mutual trust and respect, with neither party seeking to take unfair advantage of their position or influence. The Annex states that councillors and employees both have a responsibility to project a positive image of the Council and should avoid making any public comments that could bring it into disrepute. It should be noted that this provision does not seek to restrict your ability to scrutinise properly the performance of the Council or its employees. Instead, it seeks to discourage you from making unfounded public accusations. The Annex further reiterates that you must not raise any adverse matters relating to the performance, conduct, or capability of employees and public. Annex B contains some definitions of terms used in the Code in order to provide further clarity. Annex C is entitled Breaches of the Code and outlines how complaints about potential breaches of the Code are investigated and adjudicated upon, the sanctions available to the Standards Commission should it find a breach of the code at a hearing, and that the Standards Commission can impose an interim suspension while a complaint is being investigated. The Standards Commission has produced comprehensive and detailed guidance on the code. The guidance includes numerous illustrations and anonymised case examples. Some of these are taken from real cases in Scotland, Wales, and Northern Ireland, and some are made up scenarios. We're going to publish a few versions of the guidance, one with the code embedded and one without, and we're also going to make it available on a section-by-section basis. The Standards Commission has also produced advice notes for councillors on the following topics: being appointed or nominated by the Council as a member of an arm's length external organisation, such as a leisure trust or organisation that delivers property or waste management services, distinguishing between strategic and operational matters, bullying and harassment, the role of the Council's monitoring officer, the qualified right to freedom of expression under Article 10 of the European Convention on Human Rights, gifts and hospitality, how to identify and declare interests, the use of social media, and the activities a councillor can and cannot engage in while they are the subject of a suspension. In addition, the Standards Commission has produced a guidance document for members of the public on the main provisions in the Councillors' Code. It has also produced a card that councillors can give to their constituents outlining what they can and cannot do for constituents in terms of the code, and that's to help manage their expectations. For example, the card states that a councillor can seek information on behalf of a constituent, but cannot overturn a council decision on their behalf. The code is available on the Standards Commission's website, along with the guidance and advice notes. The Standards Commission has also publishes information about its forthcoming hearings, its written decisions, and its quarterly standards updates. You can follow the Standards Commission on both Twitter and Facebook. Any inquiries on the code or the Standards Commission's work can be directed to inquiries@standardscommission.org.uk. Thank you.